Gotta fix a typo. Shorthand and voice, which is not presently included in statute, so that both methods are recognized as certified court reporters. The committee report has been sent to all members of the committee and should be available on our website to members of the public. Should this not be found in our public website, please inform me and I will rectify this problem. Number 1, Part B. A task force on family law pursuant to Chapter 250 Laws of 2002 as amended by Chapter 257 Laws of 2003 comprised House and Senate Judiciary Committee members, a House Children and Family Law Committee member with further one as an alternate, representatives of guardians ad litem, judge in family division, the Commission on the Status of Men, the Commission on the Status of Women, a psychologist, members of the bar, and other organizations. They were on the task force. Interestingly, representatives of numbers of these groups have already made presentations or will be making presentations before us. They are not members of the committee this time. They were 20 years ago. An interim report under the name of Nina C. Gardner was presented on October 30 of 2003, and a fuller report under the same name on November 1st, 2004. Both of these reports contain numerous recommendations. These reports have been sent to all members of the committee and should be available on our website to members of the public. Should any of these not be found in our public website, please inform me and I will seek to rectify this problem. Number 2, second iteration, 10 years later. In 2012, there was a House Committee on the Redress of Grievances. Because I spoke of this committee at some length last week, I will give only a bare bones comment now. There was a report from Representative Paul Ingebrigtsen, Chair. There was an additional report originally published in the House Journal of March 21, 2012. Finally, there exists a legal analysis by the Honorable Charles G. Douglas III, then House Legal Counsel, dated April 28, 2015. These 3 items have been sent to all members of the committee and should be available on our website to members of the public. Should any of these 3 reports not be found in our public website, please inform me and I will seek to rectify this problem. Now, I am calling attention to all of these previous iterations for the following reasons. First, it will be very helpful for committee members to read these reports both now and periodically as we progress with our work. Second, it will demonstrate that because of the complexities of the law, the question of the degree to which arbiters should have discretion, and the fact that although all divorce, custody, alimony, and child support cases have things in common, each case is unique. So a one-size-fits-all law, rule, or protocol may be somewhat difficult to craft. Notice how the previous committees wrestled with all of this as we will be wrestling. And third reason for calling attention to these past reports, that while each iteration of looking at the court had similarities to each of the others, each committee approached and is approaching the matter somewhat differently. This diversity of style and methodology to me is helpful. It's a good thing. I'm glad we're all looking at this in different ways. Therefore, one committee does not really comprise the entire body, even of present investigation. We have these other things as precedents that inform us. Second introductory matter of today, emails, texts, letters, phone calls. As the existence of this committee becomes more widely known, communication with either me as the chairman or with all of us, the committee, is increasing. I much appreciate those who understand and cooperate with the ground rules I've laid down for conveying of information to us. These people realize, as much as they would like a do-over on their trial or a listening ear that commiserates, we, if we are to accomplish our goals, need information provided in a certain way. I especially appreciate those who understand it. And by the way, those who filled out pink cards and now said, can I be put off another week? I don't think I'm ready to do it in the format you wish. Thank you. That gives what you say the likelihood of being listened to. And I also appreciate all the thank yous that are coming already. That is comforting as we do our work. But because of the growing volume of communication and the fact that everyone on our committee has other things to do in the legislature, at home, and for some of us at our day job or jobs, we can devote only so much time to the communications sent to us. For me, and I know in talking with some of you on the committee, that means prioritizing what comes to us. Speaking for myself, top priority is communication from someone who hasn't communicated with us before or who has done it but only once. What those folks send is new information, or else in a follow-up communication back from us, clarification is made to a question about more information. It also means an increasing unlikelihood of reading everything, especially communications from the handful of people who seek to address us frequently. We've heard you. Sometimes these communications come every day or two and have demonstrated those people cannot or will not adhere to sticking to the kinds of things we choose to hear. My time devoted to this special committee is insufficient to attend to lectures on how this committee is doing our job wrongly. And it is insufficient to attend to extremely long reviews of entire cases, including personal attacks. I don't have the time for that. Perhaps there may be someday another committee that works differently and would welcome all of these things, but this is not that committee. And then finally, the third introductory matter, I have been asked to read every week the document entitled Notice and Disclaimer. So here goes again. The Special Committee on the Family Division of the Circuit Court was formed to investigate allegations of irregularities, including failure to follow or enforce statutes, unwarranted waiver of or failure to follow court rules, delay in rendering decisions, denial of due process, and other procedural issues. The committee will conduct hearings relative to the process of the Family Division of the Circuit Court and may make recommendations for future legislation. The purpose of the committee is to discover areas where changes in procedures or changes in law regarding the Family Division of the Circuit Court might be made. The purpose of this special committee is not to retry the cases of citizens who disagree with the outcome of litigation. Members of the public will be given opportunity to testify and present information to the committee. Because of the numbers of people who may wish to testify, there may be a time limit imposed on each person testifying, which is permissible under House Rule 100. Appropriate subject matter for testimony will be limited to specific instances of where there seem to be irregularities in process, procedure, or adherence to rules and statutes. Those testifying about subject matter related to a court case or who submit documentation related to a court case should know that both of these will be made part of the public record. Therefore, subject matter that is either confidential or may be under seal should not be discussed or submitted to the committee, as disclosure of such matters would be a violation of statute or a court order. And let me add, as I did last time, the committee has no way of knowing when a person is testifying, whether that person is violating these things or not. The burden and maybe any future punishment of violating is solely on you and not on the committee, so you'll have to censor yourself. And then finally, the committee reserves the right not to accept written or oral testimony or materials that would, in its judgment, violate all the foregoing. So with that in mind, we continue listening to folks from various organizations. And as I pointed out 20 years ago, they were actually part of the committee. This time I chose not to do it that way, but instead invite them to come and make a presentation. And in my schedule, I have down Office of the Child Advocate. So would that person or persons please come forward? I'm looking at my scheduler. Excuse me. Well, okay, that's not what I have. Is that person not here? Okay, I think I can work around that. There is no one else scheduled for today. Is that correct, Christina? All right. Yeah, sure. We got a few people who are who have turned in some pink cards. All right. The chair recognizes Dale Savoy, who wonderfully has presented all the specific information that we have requested on the back of the very same pink card. Well done.
I tried to be accommodating.
Well, you know.
So, and actually, you know, I also said that I would get to you the information in terms of all the statistics on fatherless homes. I'm still working on that. I didn't realize that you were going to be doing these meetings every week. So I don't have that as of yet, but I do have the information.
Okay, you got 5 minutes for your presentation, and when you're finished with that, we will be archiving your card and so on. So when more information comes to us, we can attach that.
Perfect. So I just wanted to clarify, when I mentioned my views for granting my children's mother custody and limiting my visitation to them, that was based on oral testimony that she had provided at the time, and the judge responded to. But in the actual final order, if I may read, there was some suggestions by the father that the parties could follow a nesting agreement, which is we would switch off. The kids would stay in the house. We would switch off, which seems reasonable to me at the time. Court does not find this proposal appropriate. There has been tension between the parties in the past, with father exhibited behavior that described as intense or even controlling during the marriage. No examples given. There was nothing that would exhibit that other than my intensity in the courtroom at the suggestion that I should have my kids taken away from me. And I think the judge actually used that, and that's where that's coming from and how she justified that here in this case. And goes on to say, there have been times where this intensity was also visited upon the children in a manner of communicating to them. Example, telling the oldest daughter, which they're not mentioning, she was an adult at the time, that she needed to get her shit together. I think most people would agree that's hardly an intense situation where it would be considered child abuse. And oh, by the way, we were alone and my other children were not in proximity at the time that event occurred. She also goes on to reference their involvement by the police in the past. That was an incident where one of my children was having an issue in school they were making decisions about it, and I wanted to be a party to that process. Well, my ex did not agree with that, and upon my immediate exiting of her presence, she called the police on me, and she actually used that as leverage in that hearing. And the judge requested, I don't know if the judge saw the footage of that interaction, because the police had cameras, and I think you would find that what you would see mostly in that is my a high degree of sadness in that I was not able to participate in these kinds of decisions in my kids' lives. And that did affect my kids as they got older going through. It's, you know, this goes into the part where removing fathers from these situations, and it affected my own kids, is really negative on kids. And that needs to be driven home to the court. And listening to your conversation of the prior meeting to the one that I was able to attend, you talked about either laws being broken or rules being violated in the courtroom. Well, I'm not sure that in this case that any law or rule was violated. The courts right now the judges are basically given a blanket coverage under best interest of the children. And under best interest of the children, the judge feels for whatever reason it's in the best interest of the children for X, Y, Z. There's little you can do under the law in order to hold the judge accountable for any kind of inappropriate decision making, because you're really it's up to the judge in terms of what their the word I'm looking for, discretion. They are given a tremendous amount of discretion under best interests of the children in terms of being able to make these kinds of decisions. So I'm not sure how effective, if you're limited to law breaking or rule breaking, how effective can this panel possibly be if you're under this situation? I'd be curious to get a response from this committee in terms of how, outside of rules and law breaking, what would you be able to do? And that's the end of my testimony.
Anyone on the committee have a question? Representative Long.
Thank you, Mr. Chairman. Thank you, Mr. Savoy. Now, you spoke of your adult daughter, and how many children and what were their ages?
I have 4 kids at that time, so they're roughly 2 years apart. So my youngest would have been 11, 12.
So there were 3, follow if I may.
Follow up?
There were three other children that were not adults, and their age were?
So that would have been 16, 14, and 12, roughly.
Okay, great. Thank you.
Representative Smith, Vice Chair Smith.
Thank you. I'm here. Here I am.
You are.
Thank you for taking my question. You understand that we are not an appellate court.
Yes.
Thank you for acknowledging that. What we are trying to do is determine what it would be appropriate for the legislative branch to do in terms of identifying difficulties and finding ways to address those difficulties. Did you ever write or contact the Judicial Conduct Committee?
So most of when I was going through this whole trial, most of my interaction was with my peers and friends, family that have gone through this process, and many of them have tried to do that. And almost to a person, anybody that did do that, anybody I communicated, felt that it was completely useless. And when you think about, hey, the judges have such a degree of discretion in terms of best interest of the children, how can you possibly affect any kind of change? It's difficult to describe in that. I mean, just this example alone, the judge decided based on my conduct in the courtroom that I was an intense person, an overly intense person, and that justified her limiting my access to my children. And I think if you played that audio footage to the general public, they would agree that that makes no sense. A father showing intensity for wanting to participate in their kid's life, it would normally be a good thing. But in a court setting, for whatever reason, they view that as a negative. They want you to go into that courtroom, be very restrained, matter of fact, and bring no emotion into it at all. Well, that's, I got to tell you, personally, that's very difficult to do. So
Thank you.
if I go before the this committee, what would I possibly be able to say or do that would have any kind of effective, anything that they could work on? The judge has discretion for best interests of the children. When you read through the family courts,
All right, thank you very much for answering my question.
Thank you. Representative Macbeth.
Thank you, Mr. Chairman. And thank you, Mr. Savoy, for taking my question. In your criticism of the court's order, and I'm not clear that I have your language correctly, but I think you said the court based its rejection of the nesting proposal that you had based on your controlling and aggressive behavior or intense behavior.
well, in combination with, we're going through a divorce, so there's contention there between.
Okay, so my question is, generally, the court made a conclusion and it backed it up by those observations. So is your
In terms of what they wrote,
is your-
I can't speak to what the judge was thinking, right?
So- so is your
beyond
testimony
but
that-
what she felt she could write and was justifiable when you look at the final order, what she wrote had to do with my intensity, if you will.
So my question is your testimony that there was not any evidence in the record that you did have the aggressive or intense behavior, or you wanted the judge to provide examples of what that type of testimony was?
So it's at best you could say it was hearsay from my ex. There was nothing. It was basically just he's intense, and there was nothing. There was no examples given other than the conversation I had with my oldest daughter. That was the only example given. And if that's the worst thing that I have done, I would be an exemplary father.
So may I just follow
Follow
up?
up.
So I know you didn't have an attorney, but are
Correct.
you aware, I don't know, of filing motions like a motion for clarification or a motion for reconsideration or finding of facts and
Yeah.
rulings of law that would have clarified
so-
that?
I did provide my case number on the PIN card. So if you look at that, I did try it multiple occasions. For one thing, if it's not, if your emotions are not written the way the court likes or deems it appropriate for that emotion,
So if I could
it
just
gets
interrupt.
dismissed on that alone.
Because what I was just specifically, because we're looking at, problems or irregularities in
Yeah.
the process. So you criticized the court order and said that you didn't think the basis of their conclusion was correct. So I'm just asking, for that specific court order, did you file any pleading that would have clarified or confirmed your, feeling like the court had been arbitrary in that ruling?
Well, certainly not at the time. No, I felt, I just, I don't want to say assume, but I concluded based on the information provided that in the absence of other testimony or any real cases or scenarios where you would consider that to be intense or, anything in the realm of abusive, none of that was presented. So for me, trying to so when you're given the case, you're basically assigned to a specific judge, and you're with that judge until this thing concludes. I am still going through with this judge.
So you've answered it. You did not respond in the specific
Not for the
example that you
specific-
gave.
I did do
in that-
another aspects of it, but
Thank you.
not specifically having to do with this.
Thank you. Thank you. Any other questions? Representative Ball.
Thank you, Chairman Pearson. Could you tell me if there was anyone in the courthouse who was there to help you fill out any paperwork or help direct you through the process?
No,
Thank you.
You had no lawyer. You were litigant pro se. Okay. Was your wife?
she had a lawyer, yes.
Okay, because sometimes we hear judges bend over backwards to help litigants pro se. especially when the other party has legal counsel?
That actually that did happen to an extent. At the beginning of this whole
Okay.
thing where I had a trial, I actually asked the judge, the fact that I don't have does the fact that I don't have a lawyer, will it impact the overall outcome of this thing? And if you get the oral recording of those hearings, you'll hear that, where I actually expressed concern about that to the judge, and the judge felt at the time that it would not impact her overall view.
Okay, thank you. And this is a leading question, but I think it actually is more clarifying what I thought I heard
Lead
you
away.
say. I won't have to declare you a hostile witness to do this. It's my committee. Okay. Is it your testimony that you believe your wife made numbers of accusations against you on various things that were accepted but did not have proof of those allegations?
Yes, from my perspective, she didn't actually have to. They go in knowing, her attorney, I'm sure, absolutely made clear to her, all we got to do is basically show any kind of issue of any kind. You don't have to really, in terms of the oral, all she did was say, I'm afraid, and she was shedding a little bit of tears, and that was all it took, to be honest with you.
Okay, good.
And-
That's helpful.
Yeah. So, and when you talk to other individuals in terms of having gone through this as well, they will tell you a very similar story. They don't really have to provide much in the way. The court system is set up inherently biased towards mother getting the kids, and they're going to make sure that that is going to be the outcome.
Okay, good. Thank you. That's all I need for an answer. Do we have anyone else? Thank you. Thank you for your testimony. And if I could speak to Ms. Dyer, I don't know if I've already asked you to do this, but if I didn't, I am now. And if not, I'm patient. Some states, I have been reading extensively in law books on family law. Some states seem to have a built-in leaning, I won't use the word bias, it's a loaded word, but leaning towards moms get the kids. That's the default position almost automatically. Other states don't seem to have that and have a more, it could go either way mentality. I'm wondering if you could do a little bit of research to find out, what New Hampshire is on paper, because I think I know what it may be in practice, and what a handful of other states might do that could inform New Hampshire. Because if it's for the benefit of the kids, that's begs multiple questions, the answer to which one of those questions is maybe it isn't automatic default to one parent or the other. So if you could take that liberal arts question and then turn it into real language and do some research, I'd appreciate that. Thank you so much. And now the
Mr.
chair
Chair, could I-
recognizes a presentation from the Office of Child Advocate.
Yeah, could I just follow up on your, would that be
Yeah,
okay?
that'd be wonderful.
Thank you. I'm a little surprised, I guess, by the question that you just asked, because my experience, limited on children and family law, but also on judiciary, is that those policies are in our RSAs, and I would believe in our one would hope in the training that new judges experience. And I fear that by you asking the question that the way that you did, without our hearing from the courts, for example, and others, you might have given an impression that I don't think is accurate of you prejudging that situation. And so I wonder if we might back off a little bit on that directive that you just gave to our wonderful staff people.
Given part of the charge to the committee is to investigate allegations, this is one of the allegations that I've been hearing for years. It may prove to be unfounded. I'm not prejudicing the outcome of my researchers' research.
Good,
I'm
thank
just
you.
raising the question.
Thank you very
And I
much.
could well be informed of all of the things of which you speak and would love to be.
Thank you.
But thank you for raising that. Appreciate that. And now we have a presentation from the Office of the Child Advocate.
Good morning. Cassandra Sanchez, Child Advocate for the State of New Hampshire, and I have with me today
Attorney Lissa Massio. I'm the new Associate Child Advocate.
Could you spell your name, please, for everyone?
Sure. Lissa is Lissa. Last name Massio, Mascio.
JD.
JD.
Good morning. So I am here today to present on the Office of the Child Advocate and our overlap with the courts. It is quite important to note, as many of you may know, we are independent oversight agency over executive branch child serving agencies, which includes DCYF and DHHS, as well as the provider agencies that contract with them. Then I can lead into what our limitations are, because I would like to make it very clear for this room. We do have limitations in our oversight. We do not have oversight over the courts. We do not have oversight over CASA, and we do not have oversight over GALs. Although we do interact with these entities on a regular basis, particularly in our oversight role and looking at DCYF cases, we do not have the ability to make recommendations or review the work of those entities. Rather, we work closely with them in trying to partner and educate those entities. So what I can share is that the office has spent time building relationships with the judicial system. So we attend regular judges' trainings, offering information about the office, as well as trends that we see in the office that impact the children of New Hampshire. We also participate on the Model Court Committee, where again, we have the opportunity to share trends and to work and influencing the courts and making positive progress that's going to focus on the best interest of children. We are a partner in that. We do not have the oversight or review of that committee either. And with the CASAs and GALs, we work to partner with them to offer trainings to those entities, much like the trainings that we offer to the judges. My office does receive complaints in regards to court issues, parental divorce cases, and because we do not have jurisdiction, we are not able to offer much support and advice from the office. We may refer out to another entity, or we will have to share that it is not our jurisdiction, therefore we cannot assist them on that case. We do not have a great data system that's able to, for us, we tried to go back and look in our data system to find how many of these we receive per year. Our system is not ideal for analyzing that kind of data, so we were not able to pull. In the few that we were able to look closely on some case examples, I can highlight some of the examples that we have heard in regards to issues with the court that parents have called in. But again, these are not cases that we have provided any guidance or review of. And so when those that we did pull, we had a number of them that were ongoing divorce or parenting cases, some of which included DCYF, where either one parent or the other was calling into central intake, calling allegations in against the other parent. So we've had a number of cases that have had that issue. We will inform them on the DCYF process and what it means to have an open assessment and have them entering the home and reviewing the home, but that's education is the minimal that we will offer on those cases. We have also had some with complaints about GALs, where parents have shared that they feel one parent is favored with a GAL over another. Some even providing at the call in, providing documentation, either emails or some other documentation they may have with the GALs, where there's information that a GAL may have gone to one family home to assess that home, not the other. Constant communication with one parent, not necessarily the other. In those that we have seen, we have not seen a preference of a mother over a father. We have heard both sides pretty equally. And again, we are counseling them out on those ones, educating whenever possible, sending them to the correct entities for complaints if they do have complaints against the GALs or the judge's decision. We send them to the correct entity for that. What I can share that we are aware of and have reviewed quite thoroughly, and many of you may be aware of as well, is the Massachusetts OCA had an opportunity to do a report on the Harmony Montgomery case and looking at the concerns that arose in Massachusetts before Harmony came to New Hampshire. And one aspect that they did highlight was the issue with the judge sending the child across state lines without full information about the child's needs and what would truly be in the child's best interest, and feeling that in that case specifically, the lack of judicial oversight and oversight over some of the attorneys, and in that case, I believe there was not a CASA but GAL. So the oversight over those entities they felt was lacking. And that is something that we have discussed with them and we continue to explore. But again, it's not currently within our jurisdiction. And speaking to our partners in Massachusetts, they currently have a similar like committee in which they're going to be further exploring that issue and how they can either stretch oversight or how there can be some processes in place to ensure this doesn't happen to children in the future.
Could you
Yes.
suspend for the member to ask a question?
Absolutely.
Thank you. We all have read about that painful case. But my understanding is that that was the Massachusetts court system. It was
Correct.
not the New Hampshire court system.
Correct. What it does highlight for us is a question about the oversight of courts and those proceedings. Not that we've made any specific recommendations to New Hampshire, but something that in reviewing such a high profile case, it's important for our office to look at the recommendations that they had coming out of that report. And one of the large recommendations they had was to look at their judicial system.
Thank you.
Yes,
You may continue. Thank you.
absolutely. So I've also noticed in my time, and I believe I heard the last time when Director Ribson spoke on behalf of DCYF in this arena here, there was a lot of talk about trainings for parents' attorneys. And that is something that I have engaged in conversations with others, especially in regards to the model court committee, and really talking about what training do parent attorneys get. And there is agreement by many folks that engage in that committee that we do need more skilled attorneys available for parents. So I would agree with Director Ribson on that recommendation, that attorneys that have a specialty in the family court issues, in understanding child abuse and neglect laws specifically, as well as some understanding in psychology and children's best interest would be ideal. So really finding a way in which we can build up a pool of attorneys that can do this work and then provide extensive training to that group of attorneys so they can best support their clients in those cases.
Is this wonderful idea progressed to an outline or a proposal yet? Because it's a wonderful idea. in my
Not
opinion.
yet. No.
It's coming though, right?
I hope so.
I
We've
do
been
too.
having a lot of discussions about it, so I do hope so.
Good,
Yes.
thank you.
And I recognize another aspect that Director Ribson spoke about when he was here before the group that I have had experience working with. So I did want to share my personal experience working with this model. Much like New Jersey, Massachusetts had a model where some of the public defender's offices would have a social worker on staff. And that social worker would work to support the parent, would work with the agency and really understanding what change they were looking for from the parent, and then ensuring whatever providers or treatment recommendations were going to be made were not only a good fit for the parent, but were also going to meet the needs of the agency. And so they were a great neutral party in between to help tie the case together. And in my experience, I would see cases move along more quickly because parents were willing to take the advice of a neutral social worker and their recommendations rather than an agency where there's that very complex relationship.
What a great idea. How far is this towards a proposal?
Again, the same space as the other. It's in discussions at this point, not a proposal. We do understand in those that have discussed these options that it will take funding because it will require specific staff in place. And specifically when talking about social workers in these positions, we have a shortage of social workers in other places in New Hampshire. And so we have to be very mindful of anything that is going to be a proposal to be built out, that the staff will be available first so that we are not pulling from our other mental health supports in the community.
Remind me not to give you the address of the facility I manage. We're all looking for helpers.
I
get
know.
it. Thank you.
Yes. And another aspect that is I just wanted to bring it to the attention of this committee that we have heard is becoming more complicated over the recent year or so, is that the courts have been able to, through the Superior Court, are now able to provide guardians to children that are in DCYF custody. But the guardians aren't necessarily the placement option. And so we've heard a handful of calls about that issue because the guardians are attempting to work with the agency, but in a different role because they are not the person who's been found to be abusive and neglectful of the child. And then the courts don't know how much access to give these guardians. And so we hear that they are often sent back and forth between different courts, the court that gave them the guardianship and the judge over that ruling, and then the DCYF court where they are a party to the case, but then are being told that they're limited, while the other judge is telling them they are the guardian and they have right to certain information. So this is something that's new in New Hampshire and something just to be aware of, that there is the option for there to be a guardian, but also children to be removed from their biological parents or their prior guardian.
Yes, Representative Macbeth.
I just wondered if the child
okay.
advocate would clarify for everyone the difference between a guardian and a guardian ad litem.
Yes, thank you. Yes, so the guardian it's typically a relative or a family friend who arrives at court and is presenting to the court that the child does not have a parent caregiver and is looking to take over the parent caregiver role. And so they are in some way linked to the child, and they are able, through this court guardianship, they are able to request records and make decisions on behalf of the children. Typically, when we think of guardian, we would think of somebody who goes to the court, gets the guardianship of the child, and the child resides in their home. And so it's very similar. The difference now is that they're allowed to be guardian without the child living in their home. And on those cases, there is still a guardian ad litem who is assigned to meet with the child, family system, and bring forth to the court what is in the best interest of that child.
Representative Smith.
Thank you. In the example that you just gave us, with two different judges and two different courts, are each of those judges in the family court?
Yes, but they could be different areas because the guardian could be going to one court and the DCYF is going to another court because of where the parent is residing at the time that they're going into court. Sometimes they can be different judges in the same court.
So that,
Follow up.
if I could just follow up, so that this is, to me, an example of an obvious area to consider for recommendations about what the family court might consider doing in order to better meet the needs of the citizens of the state. And that would be coordination in that case.
Yes. Yes, and we hear similar in some of the parenting or divorce cases where they may become DCYF involved while they already have this other case in process. And then a family is sent to one court or judge to deal with their DCYF case and another court or judge to manage the parenting plan and divorce parenting decisions. And so I do believe that taking a look at that and if there is a way to incorporate, if there is already a parenting case or divorce case open and it is a similar judge to hear the DCYF case, it would reduce the missing information going back and forth between the courts and reduce the amount of times that the families have to go to courts, because they could have court in the same week for two different types of hearings.
If I could follow
You may.
up. Thank you. So i- would there be any benefit to the family court having a policy of one family, one judge?
Yes, I do believe that would benefit the family as well as the children specifically. Really having a good understanding, especially when we're talking about abuse and neglect being looked at in the courts. If that is not understood by a court that is putting into place parenting plans, we worry about putting children in at-risk situations because that court does not hold the same information that the other court holds around the abuse and neglect.
Procedural thing to
Yes.
the clerks, this could be something to be noted as a point, it already is. Thank you
If
for
I-
18.
If I may,
may.
having worked as an attorney in both of these arenas, I was a DCYF prosecutor and I also worked in the private family law sector for quite a long time. They have that policy, but essentially family court is two completely separate courts, the DCYF realm and then the parenting realm. So each of those different realms do have that policy. I believe Mr. Savoy just testified as well. In a divorce case, you typically are assigned one judge. The same judge stays with you through your whole parenting divorce case. Same thing happens in DCYF cases. It is the one judge who is handling a DCYF case, again, for that continuity. But even though they're both under the guise of the family court, they are separate courts. So you can have one family that has a one judge parenting case, one judge DCYF case. And it is very confusing. A DCYF judge will typically maybe enter a temporary parenting order in order to close a DCYF case, but then yes, the whole thing goes back to some other judge.
Well, thank
Yeah.
you very much for that. If
Go
I
ahead.
could,
Sure, you're on a roll.
you are telling us the way things are. What we are interested in is the way things should be, which isn't necessarily, it might be, but isn't necessarily the way things are. So you've helped to clarify the way things are, but we want to make sure that the way things end up being is the best possible way in the interests of all the citizens of the state. So
And we have noted this now on what will be a list of discussion topics when we get the various slices of cases from various people and put them in their appropriate folders and then open the folders one at a time. This will be one we will open. We will invite people from both aspects of family court to be here and a couple of other folks, and we'll just chew into it to see if we want to make recommendations, whether to keep what we have or make a change.
And just to throw another wrinkle in, if there is a domestic violence situation layered over on top, that is potentially another judge in court who's involved with that family and those children.
Thank you for that wrinkle. Representative Macbeth.
Thank you. And thank you for taking my question. It's my understanding right now that the judges that would have these individual cases in the silos, the protocols don't allow them to reach out and talk to each other, correct? So it would have to take the party that may not have an attorney to move to join those cases. So the protocol or the recommendation we'd be looking at that the judges themselves, through whatever kind of, computerizing, looking up families and trying to make connections, they themselves would be able to connect and try to work out who should be handling what part of the case or the entire case. Is that kind of a recommendation we're looking for? Or is that something that we need to ask the judicial?
I would ask the judicial, from my recollection, the judges can certainly see all of the cases in the court system. I don't believe they're prohibited from communicating, but I don't know how regularly it happens. I would defer to the judicial system.
any other questions? No, if you could proceed. Representative Long has a question.
Thank you, Madam Chair. You stated that you are involved in judge training when it comes to the best interests of the child.
Yes.
Okay, and in those conversations, is there a topic on gender neutral care for the child? The ability for, a gender neutral care for the child?
So that is a great question. No, there is not right now. That is not something that we incorporate into the trainings that we have. We are typically one small aspect of larger trainings that they interact with. So given the amount of time that we have to gather all the judges together and have an opportunity to train, we don't get to a breadth of topics that cover all of best interests of children, although ideally that would be wonderful. So no, that's not currently in the training that we provide, but it is something that I believe is very important for the judges to be well aware of, because we are seeing a lot of needs for that with our children today.
And if I may just confirm what I thought I heard also is, when you get calls with respect to divorces, you're seeing a balance with men and women with respect to custody?
We get calls from both parents. And we do not have, just in trying to look at some of them quickly, we do not have a larger amount of fathers calling as we do mothers. It's quite equal, and there is custody going in both ways on those.
Okay, thank you.
Yes.
Thank you. I'm trying to pull up the parental responsibility RSA, which guides judges. There's about 13 enumerated ones. And our statutes do instruct judges to be gender neutral, that there's no preference, to give no preference to either sex. That doesn't mean that the judges wouldn't look at who's had the traditional responsibility of that or who's able to look at that going forward. And I will provide those. I think those are important, and I will send those out afterwards if I can't pull them up now. But so our statutes do say that. That doesn't mean that, their protocols don't say that. All right, thank you.
I don't have much more to share. Again, our jurisdiction is quite limited when taking a look at the courts. So we did want to come here today and be able to present what we do have for you, but also to make sure we could clarify that aspect, because there is a misconception that we have the ability to intervene in court cases that are divorce parenting cases only, that do not have a DCYF component to them.
Thank you. Anything else? Yes, please.
Thank you, Madam Chair. A question for you, Ms. Sanchez. Specifically, you spoke of this, I call it alleged, model court committee, and that you both, or maybe just one of you, attend. Would that be correct, one or both?
Lissa is new to the staff, so she will be attending in the near future. But up until this point, I have attended, or others within the office. So the previous associate child advocate would also attend prior.
Okay, one follow-up, Madam Chair?
Certainly.
Then specific to your statement of what the Office of Child Advocate does, and a lot of it being that you don't have oversight over the various components that when folks come to you, then what is it that you bring to the table that we can utilize in changing the parameters of operation, and we can get it done while we're young on this? Because it's a serious matters of families being affected today, is if there's new rules or rules of performance in the court, do we need a consolidation as referred to have a one family, one court, one judge? Or what have you learned, if anything, from the model court committee?
From the model court committee, we talk often, in the role of my office on that model court committee is to ensure that when we're talking about court improvements, we're keeping the children at the focus and at the center of that when we're talking about parenting in any form. And so my role is really to ensure that any new protocols or procedures they may be looking at have the children's best interest in mind in them. We've also learned that it's quite important to have children involved in court proceedings whenever possible. So that's another aspect that is not happening everywhere all the time right now, but is something that is encouraged to happen, is to have the children be able to meet with judges and understand what is happening. What we know is that children oftentimes are left out of that process, but they know something is happening. They know there is some kind of court proceeding or there is some back and forth about what their future holds. And they need to have more of a voice at that table. And CASAs and GALs are great and have the opportunity to do that. But there are also times where it is better to be heard from the child themselves and not rely on an adult, because we do understand that although they have a role to fulfill, which is the best interest of children, it is subjective because it is somebody else reviewing what is in the best interest of that child. It's not the child speaking on behalf of themselves. So that has been one topic of discussion in that arena. As well as what I had talked about, the difficulties of these different courts and interacting and understanding that it adds a lot of complexities to the family system and to ensuring that all of the information is getting to the judges when parents are going to different courts. Is all of the information carrying over accurately?
One final,
Yes, certainly, Representative Bennett.
relative to what the previous contributor, Mr. Savoy, stated, and that was and I say so-called because you just changed the debating platform, is who do we hear from? Not the parents, but from the kids. And if, to achieve that, the best interest of the children, do we need that to take place in rules of evidence or in rules of the court?
So it needs to incorporate, it does, of course, need to have the component of the parent piece. So in that committee, my role specifically is a focus on the children, but there are others that come to the table with a background in prosecutors for parents, and as well as parents' attorneys coming to the table. And it's really important to have all aspects of that coming together, because my goal does need to be focused on ensuring that children's best interest is kept in that regard. But of course, we have parents' rights that are important that we need to respect in this state. So there's another entity that is at the table to speak on that regard. And that's why we need a well-rounded committee of folks that all engage in this work at different levels to come together. And that is what's happening right now with that group.
One last one, Madam Chair.
Certainly, Representative Bennett.
Thank you for your patience. Attorney Marcio, then, based on, thank you for taking the job, by the way. You're on the front lines on this. Do you have a recommendation at this early point on what a rules of evidence or rules of court change or recommendation from you could help us as we change the parameters of operation going forward?
I think there are a lot of entities that can speak to that. Their rules of evidence do not apply in the family division. The protocols that have been discussed, that are being discussed by the model court, is, I think, where most of this would be found. Although, as Representative Macbeth stated, the RSAs around both the family division, private parenting cases, and 169C, the RSA relating to abuse and neglect cases, first and foremost is best interest of the children in both of those statutes. As far as taking evidence from children, I think probably the judicial system would want to address that within their protocols. I know some courts do speak to children in chambers, take letters. It's really depends on the judge. So again, I think that's something the model court discusses as far as consistency amongst all the courts, how those protocols are written. And then I know Attorney Baker was here last week. I used to work for her, and how the new judges are trained to make sure it's consistent. Because I think that is a trend we also see, is just simply because it's discretion of a judge, it's going to depend on your judge. So it does feel like a lack of consistency, I think, for people across the state.
Okay, thank you very much.
Representative Long.
Thank you, Mr. Chairman. Do you have data on judges that speak with children or receive letters? You don't have that.
We do not know, but as Lissa explained, we hear from certain courts that this is what they do. So we don't have the exact judges. It will just be this court operates in this way, and we think that this is best practice. And so how do we then spread that? That's more discussed in that the model committee meeting in that way.
Thank you.
Representative Katab.
Thank you, Mr. Chairman, and thank you for taking my question. Are you aware, could you just give an example of any of the courts that are allowing the children to speak? Just, I think it would be nice to know an example of it and maybe be able to get some information, you know, us as a committee to see how it's working for them, you know, how they've implemented to know, to make it, you know, not to be at the discretion of the judge and not, and to be more uniform and consistent. Can you just give us any example that you're aware of, any court that you know that may currently be doing that, just so we may be able to, you know, gather some information from them on how they're doing it?
I don't have any specifics of the exact courts that are doing it. I would send that question back to the Judicial Committee. I believe that they would have a better understanding of it. Often I leave the specifics of what court is doing what to Judge Ashley and rather focus on with her whether it's effective or is working well.
You may continue.
That is all that I have.
You
for
may
today.
finish. Thank you for coming.
Wonderful. Thank you.
Mr. Chair, could I just ask Representative Macbeth to give us the RSA to which she referred that I think would, I gather, would answer a number of the questions that were raised today?
Yes, Madam Vice Chair, you may ask her that.
Thank you.
Thank you. So I did find it. So it's RSA 461A 6, the determining of parental rights and responsibility best interest. So then Roman numeral number 1 lists the 13 or whatever criteria. And then when it gets down to Roman numeral number 3, this is the section that I'd referred to. It's just a sentence long, if I may read it. It says, in determining parental rights and responsibilities under this section, including residential responsibility, the court shall not apply a preference for one parent over the other because of the sex of the child, sex of the parent, or the financial resources of the parent.
And what subsection is that?
That is Roman numeral 3.
3 of 461A6.
Yes,
Okay, good, thank you.
you're welcome. Thank you.
All right. We have scheduled for next week, in terms of people coming before us, at 9:30, the New Hampshire Bar Association, and at 10:15, the New Hampshire Legal Assistance people, I think, if I'm correct. I am, thank you. Representative McMahon?
I want to ask Rep Macbeth on the section 3. If you could just read that one more time, or referring to wanted to ask a clarification on that.
So thank you. Just let me, you want me to read that, Roman numeral 3?
Yeah.
Okay. Yes. In determining the rights and responsibility under this section, so I remember I said section number 1 lists those 13 criterias that the court or considerations. So in determining the parental rights and responsibility under this section, including residential responsibility, the court shall not apply a preference for one parent over the other because of the sex of the child, the sex of the parent, or the financial resources of a parent.
Okay. And so, yeah, what I wanted to ask, your guidance on this is, does that come under the quote judge's discretion on whether to carry out that specific black letter law determination?
So I could give you my interpretation of it, but I think it would be better if we talked directly to, the court. But the statute, which we wrote, this committee, your committee wrote, it says, the court shall not apply a preference for one parent over the other based on the sex of the child, the sex of the parent. So to me, that is pretty a directive that they shall not do that. So usually that would eliminate the discretion again. But when you go back up to those 13 criteria, and I'm not going to read them all, but it's, the relationship that each parent has with the child, and B is the ability of the parent to ensure the child receives clothing, medical care, shelter, the developmental needs of the child, the quality of the adjustment to the school. So you've got, like 13 or 10 of those things that are subjective. But as far as when the court applies, just solidly, it says it shall not based on sex. So, but I think we should talk to them.
Right.
Judicial branch.
All right, thank you.
Anything else? If not, the chair recognizes Greg Lombardo. Good morning, Mr. Lombardo. Thank you for being here. Yeah, press the, there you go.
All right. Again, I am Greg Lombardo. I'm a divorced father with 2 little kids, ages 3 and 4. My daughter's almost 5. I've had 50-50 equal shared parenting since the beginning of my divorce. Parenting plan established with a 2-2-3 equal shared parenting plan. However, I am forced to pay full guideline child support. I supply the exact same for my children as the mother does, except health and dental insurance, which is compensated for in the child support calculations. So right now I do kind of pay for half of everything. The judge totally disregarded that I have the exact equal burden of child rearing as the mother does, or the fact that she supplies nothing for the children when they are with me 50% of the time. The judge stating, although parenting schedule is a shared one, it does not reduce wife's fixed cost of child rearing. The most recent uniform support order has my income at $1,168 more than her income. My child support payment is $1,144. The net result has her having $1,120 per month more income than me. The court also states that she needs guideline child support to be able to afford to provide the children with the same or similar lifestyle as the husband can provide. The court makes no notion or recognition that inherently they have swapped our income almost completely. Now I cannot afford to supply the children with the same or similar lifestyle as the mother can provide. The court also failed to add the child support amount into her income when attempting to justify its decision, stating the net result of the above modification is that the husband will pay child support of $1,144 and $433 a month for daycare, for a total monthly payment of $1,576. After paying support in daycare, he will now have $3,620 in monthly income to pay his and the children's expenses. Wife will pay daycare of $433 a month, and thereafter will now have $3,595 in monthly income to pay her and the children's expenses. The equity of this result is obvious, is what it says. As you can see, they never added what I pay her back into her income, so now she has that more than me. Using the child support guideline worksheet that was used to figure my payment provides information that could be easily used to make a better and more justifiable child support payment, especially when having 50-50 equal shared parenting. The worksheet breaks down our incomes and expenses and creates both of us a parental support obligation amount. My obligation is at $1,144 and hers obligation is at $785 and some change. If you were to use a net the difference way of figuring child support, would put me at a payment of $359 a month in support. The net result would have me making $486 per month more than her. My income after paying support at $4,873 per month, and her income after receiving support at $4,387. I believe that this income is a lot more fair, leaving the higher earning parents still earning slightly higher while still paying a fair amount in child support per month. And one thing that has been also brought to my attention is how having these heavy child support payments when you have a child, so children even close to 50% of the time, creates an environment where neither parent wants to better themselves due to not wanting to possibly pay more in child support or receive less in support, trapping families like mine into essentially staying neutral when we should be growing and bettering ourselves for the benefit of our children. Having a sliding scale parenting time versus support payment or net the difference model to create the child support payment would allow both parents to better themselves without being penalized by doing so. That's all I have.
Representative Alexander.
Thank you, Mr. Chair. Thank you, Mr. Lombardo. I'm wondering specifically how the court has to do this when you disagree with the child support payments.
Yeah.
What does the appeal process look like? Can you tell me a little bit more about that? And have you seen any issues with that appeal process?
It's been going on for 3 years. So I've been to the courts every chance I get trying to fight this since it was established early on. And no matter what I kind of say in my appeal, it just goes back to that she still has the burden of child rearing. And I believe it actually states too, that even having your child 50% of the time does not justify a deviation from child support payments or full guideline child support payments. It's basically up to the judge to decide if you qualify, which my judge did not.
Representative Smith.
Thank you. I guess I'd like to ask the chair of Children and Family. It's my understanding that it is the legislature that, in fact, has worked very diligently over the years to try to come up with the right formula for child support. So if it's not working, would that not be a problem for the legislature rather than the judicial branch?
We would first have to stipulate that it is the legislature's responsibility, and I have the book here, and I'll go looking through it. And if it is not the legislature's responsibility, we go in one direction here as a special committee. But if we discover it is our responsibility, then we can discuss that for possible legislation. Representative Macbeth.
Thank you, Mr. Chair, and thank you for taking my question, Mr. Lombardi. I'm wondering if you would be willing, if you redacted your names and the bank account numbers, to provide a copy of your financial affidavit and the child support worksheet, because it's my understanding that there are things like housing expenses and other debts that are maybe considered, and also the existence of other adults living in the household that are contributing that do factor into your child support calculations. So it would be helpful when we were analyzing this, what's equitable, if we could see really, what other factors might have gone into the child support calculation.
Yes, I have some of them with me today. I was planning to hand in, but I can also get more, what you're looking for.
That would be helpful. It gives us all the more strength in arguing one thing or another
Yeah.
when we have the documents in our hand. It's not that we distrust people.
Right.
It's just, it gives us more oomph behind us.
Yeah.
Thank you. Representative Long.
Thank you, Mr. Chairman. Thank you, Mr. Lombardo. We do have retained bills on this subject matter, so
Yeah.
there may be some benefit there for you. With respect to extracurricular activities for the children, I know they're still young.
Yeah.
Maybe for one, does the mother have, like dance lessons or karate lessons or what have you? And do you have extra things you do with the children?
Right now, like being so young, we kind of do stuff together. Like my kids just started t-ball. My daughter last year played soccer, and we just split those costs 50-50.
Okay, so you split them.
Due to so there's nothing in our parenting plan that establishes what she's supposed to be paying for with her guideline child support. So she has been refusing to pay for or enroll my kids in anything unless I pay for half of it, up until recently where I'm taking her back to court again. Now she's starting to try to pay for things on her own and prove that she's been using this money, towards the children, when in fact I have evidence, stating otherwise.
Okay, very good. Thank you.
Seeing no other questions, thank you so
Sure.
much for your
Thank you.
testimony, and we'll accept your documents, and please understand that they become part of the public record.
Okay.
So if that part of it is a problem, what I have done in my other committee before is I have read over things to attest that what is alleged is in fact on the document. But once it comes in, anybody can look at it.
Okay, I'm just gonna read through my stuff real quick and then.
Sure,
I'll hand it in.
that's
you.
fine. Chair now recognizes Mr. Thomas McCarthy. And just remember the ground rules here. We're looking at a slice of a case in which there is an alleged violation or problem or whatever, so that we can look at that issue.
Okay. I'm 2009, I was called by the local police department in my town saying there was a restraining order on me. Okay, I asked why. Said you just can't go home, there's one been pulled. So automatically, your 14th Amendment due process for every American in this country is eliminated. The state or the federal government can't do anything until you have your due process where you get to face your accuser in a court of law. That's a huge issue. I showed up 10 days later after I filed to have a hearing on the matter. The petitioner was asked by her attorney to tell the court about all the violence, emotional, physical, verbal, that she suffered over the years with me. Her answer to the court was, "I'm trying to remember." I raised my hand, pro se litigant, said, "Your Honor, I've never harmed my family. I'm the protector of my family." The judge said he'd give a decision by noontime. I waited in the court all day. They said, "Come back Monday." So I came back Monday, and I was handed a decision that I was a credible threat to my own family. I do have the 911 call that was made, which is a matter of public record. And if you just give me 1 second. While I'm pulling this up, I just want to let you know that the New Hampshire statute is for one judge.
Any dogs there that could be aggressive when the officer gets there?
Not at this time.
I'm sorry. Let me just. After supposedly I attacked them. Nothing yet. 2 days went by. Saturday, went to a birthday party. We came back. There was a couple of bags in the hallway. I asked my wife, "What's this?" He goes, "Oh, me and Kaylee are going to my mother's." Okay. Now, my dogs aren't in the house. Sorry, I went a little too far. This is on a show I was on with Senator Kevin Avard. It's called Speak Up. Called 911. And he asked me to play this 911 call. Domestic issue. I'd like you to hear the 911 call.
All right, let's take a listen to that right now. Emergency dispatch?
Hi there, this is the Danville Police Department.
Dispatch, those calls, can I help you?
Yes, my name is Christine McCarthy. I live at 61 Fry Road,
Okay.
Danville, New Hampshire.
Yeah.
I'm having a domestic issue, and my husband is not allowing me to leave with my child.
Okay, are you at 382-0730?
I am.
Okay, hold on 1 second.
So we don't have to leave the lights and sirens. He hasn't done anything more than just tell me he's not going to allow us to leave.
He calls 911, but you don't need the lights or sirens.
Okay. And so what's your husband's name, first of all?
Thomas McCarthy.
And your first name is Christine. And what's your date of birth, Christine?
2765.
What's his date of birth?
9/21/59.
69, like 5'9"?
Yes.
How many kids are there?
One is only 6 years old.
Okay, and you, what's your daughter right now?
I am at the basic stage and she's up in her room
And where's her husband?
in the living room.
But, no assaults, right? I mean, you said you didn't do anything.
No.
I didn't do anything.
Yeah, obviously there are no restraining orders in the back.
No, not at this time.
Not at this time, she said.
Okay, hold on 1 second.
Yes.
You've gone over your allotted time, so could you wrap it up in
I
about
did?
30 seconds, please?
Oh. Okay, well, there's supposed to be one judge for one case in one court. That's the New Hampshire mandate. I've had 8 different judges sign off, 2 marital masters, 2 GALs, a visitation center that I had to go to see my daughter. After 10 months of not seeing my daughter at all, after she had a nervous breakdown, was on suicide watch, because all she kept asking everybody is she wants her father in her life.
Sir, thank you for your testimony, and we appreciate it. Do you have anything you wish to hand us? Any handouts or documents? Okay, we've given you well more than the normal 5 minutes. And the chair now recognizes John Kelly. He has written testimony that he's going to send along later. And thank you, sir.
Good morning. John Kelly, Concord. A man goes to the toy store to buy a birthday gift for his granddaughter. The sales lady brings him to the Barbies, and she says, "This is Barbie Goes to the Beach. This costs $29.95. And this is Barbie Goes to Medical School. She costs $29.95. And this is Barbie Gets a Divorce. She costs $500. Why the difference? Oh, this comes with Ken's car and Ken's house and Ken's 401k. That joke spoke to me because in my divorce court experience, I saw the courts divide families into winners and losers, and I was a loser. I also felt the sting of gender bias. The best legal advice I got was that I should not expect to be treated fairly. I was the wrong gender. I was lucky. My losses were mostly financial. I lost my life savings, I lost my retirement, and I lost my faith in the courts. But I did not lose a child, or my freedom, or my will to live, as others have. How can the family courts earn public confidence, including mine? From my own experience, as well as my conversations with other people who have been affected by the family courts, I have 4 suggestions. The first reform is to establish a mechanism by which the public may test the courts for gender bias. Perhaps something as simple as tracking the percentage of times a judge rules in favor of male or female litigants, and making that information public as part of a job review. In addition, the public needs an independent board to investigate complaints of judicial bias. This should not be judges judging their colleagues. It must be an independent body. Another necessary reform for the courts is to take perjury seriously. Perjury is a crime. It should be treated as a crime. Closely related to the issue of perjured testimony is the strategy of filing a false report of domestic violence or child abuse in order to gain the upper hand in a divorce proceeding. This strategy is devastating not only for the falsely accused, but it also undermines the credibility of real victims. Filing a false report should be treated as a crime, and the falsely accused should be entitled to damages. Number 3, under the current system, parents fight over children. This is bad for the courts, bad for the taxpayers who fund the courts, bad for the parents, and especially bad for the children. The only ones who benefit are the lawyers who promote the fighting. A solution to this problem is for legislators to pass a rebuttable presumption of shared parenting, and then to ensure that the family courts follow the law. A fourth problem is the court's lack of respect for prenuptial agreements. I lost my life savings because our prenuptial agreement was not written down. Mark Twain once said that an oral contract is not worth the paper it's written on. That's a funny line, but it does not solve the problem. In New Hampshire, oral contracts, especially contracts like mine, which were corroborated by years of documentation and witness testimony, oral contracts are valid except for prenuptial agreements. That must change. I have a suggestion. Divorce lawyers will not like it, but it is good for everyone else. We can make divorce less adversarial and less profitable by requiring a filed prenuptial agreement as a condition for getting a marriage license. This requirement means that couples will negotiate while they have a cooperative relationship before the courts have turned them into adversaries. Mr. Chairman? I mean that as a signal that I've finished with my prepared testimony.
Yes, sir. Are you willing to take questions?
Oh, yes, please.
Representative Long.
Thank you, Mr. Chairman. Thank you for your testimony. What year was your divorce?
2003.
2003. And follow up, if I may.
Follow up.
How long was the process, or are you still involved?
Well, the process has felt like it's been 20 years, depending on how you measure it. But the actual day in court was 6 hours.
And your final decree?
I kept about 5% of my assets, and
When was that finalized?
April 2003, I believe.
Great, thank you.
Representative Alexander.
Thank you, Mr. Chair. This has been very helpful. I would expect nothing less from my 10th grade English teacher, who taught me how to write a paragraph. Can you please send us all of this in like just written out? Because I wrote down some of it, but I think there's been some very valuable things said. So thank you.
I will.
Anyone else? Seeing no further questions, thank you so much. And may I go out to recess now? Yes, sir. Chair recognizes Jackie Wydola. Did I get the name right?
You did. Good job.
Yeah, Jackie, I've done that one before, and Wydola I took a stab at.
You did well. It's only 6 letters. We did a good job at Ellis Island. My name is Jacqueline Wydola. I live in Newmarket, New Hampshire. I'm here on behalf of my deceased sister, Mary Wydola, who and this was her experience in the district court. This case arose from a domestic incident on May 20th, 2017, when the child in question, Benjamin Van Billiard, was 6 months old and had since that time been living at home with his mother and father, Mary Wydola, and Brian Van Billiard. The purpose of this letter is to bring to your attention the evidence that was provided against Mary that Attorney Finney and Brian Van Billiard knew to be false. This false evidence resulted in the Honorable Judge's decision to grant Brian Van Billiard a no-contact order between the child and full parental custody of the child until the next hearing. Mary had no representation at the time, as it was an ex parte motion, and being unaware of the process and just acting in good faith about the restraining order in place between her and Brian. Attorney Finney and Brian knowingly presented perjured testimony during the ex parte hearing with the intent of discrediting her motion. Brian and Attorney Finney succeeded in this, and Brian's objection to the ex parte requesting a no contact order was granted, and Brian was also granted full custody of Benjamin until the family courts would review the matter. I have some attachments of Brian's objection to the ex parte motion. This is dated June 9th at 11:49, meaning that Mary filed her ex parte motion of relief before 11:49 on June 9th. On July 7th, 2017, the court held the hearing on the petitioner's emergency ex parte motion. It was during this hearing that Brian Van Billiard and his counsel, attorney Catherine Finney, I just want to make sure her name is stated, that counsel attorney Catherine Finney stated that Mary Wydola filed her ex parte motion as a way to avoid having no visitation rights in the no contact order 618-2017 DV 00074. Now, this case number is not the case number cited on the ex parte motion. That would be sorry, 435-2017 CR 795. So we go from a civil ex parte on a domestic violence to now we find ourselves in a family court on July 7th as it regards to the baby Benjamin Van Billiard, who is now 7 months old and has had no contact with his mother for 21 straight days. So, Attorney Finney alleges that Mary filed this ex parte motion as a way to avoid having no visitation rights pursuant to the no contact order that had not existed at that time of Mary filing. The documentation I'm providing shows this to be false and that Brian and his counsel knowingly lied and took advantage of the lack of representation of my sister on that day. On the morning of June 9th, 2017, I accompanied Mary to the 10th District Division in Brentwood at or around 10 o'clock, and the purpose was to file the ex parte against the Protective Order 435-2017 CR 795. This request for relief stated that Brian was falsely interpreting the order of protection to prevent contact between the child, Benjamin, and Mary, the mother. So that is, anyway. So those are, I've already presented you. So the request for the relief stated that Brian was doing that and that we would like to have a move up our court date on case number 435-2017, and that Mary would be able to expose to the court that this protective order between the parents was allowing him to bar contact from the child because she could not hold him accountable. She could not contact him. On this order of protection, it only states Brian Van Billiard's name. The additional protective parties, number 2, number 3, number 4, are filled in NA. I also have a current copy of that where you can see Brian Van Billiard's name is the only name that has the protective order. So nobody else Mary is barred from having contact with. So at that point, that was the 21 days later that Mary had not seen her child. Nobody in my family had seen my newborn nephew. The ex parte Mary filed clearly states that it was this court date of 435 and not court case 618, as Attorney Finney misrepresented. So at this time, we were on the courts. I was there as a witness. The other order did not exist, and Brian had not yet filed it. Brian arrived afterwards. While we were there, he was served his paper at 11:30, and shortly after this, he began the proceedings to file the protective order between the child and my sister. So it is only logical that his objection motioned had to be after he was served, whereby the timestamp on the protective order between the child and the mother is stamped at 2:17 p.m. on the same day. So we believe this should have been obvious to Attorney Finney. We believe this should have been obvious to the judge handling the case, that he has 2 different protective orders filed on 2 different days, and that Mary whereby is not violating the later existing protective order that did not exist at the time of her filing. For this reason, I respectfully conclude that Attorney Catherine Finney misrepresented the information to defame my sister and impede justice. I would like to just bring up that, you know, RSA 641 is perjury. We had another person bringing that up, and that this false material statement was provided. It was inconsistent with what was actually happened, and it was plainly false. It was known to be false. All of these just illustrate that there was there was no oversight. All of this, the judges and the lawyers now just made this decision, and because we went from a civil case about domestic violence and now we were in a family court, the judge's decision was law.
30 seconds. So give us the points we're going to consider, because in this iteration of the committee, we're not looking at specific names of people to bring charges against. We are simply looking at procedural issues. that
Sure.
may
So I
regularly be
suppose the
going on.
procedural issue that the DCYF and that other parents have brought up is that there is no oversight. The first parent that gets the restraining order has the benefit of all the force of the court. I don't believe that that goes male or female, but I do believe that females tend to get restraining orders first. And maybe we would look into that which, you know, who's working male and female with DCYF, with these organizations, and who's winning, the ones that are playing ball or the ones that have a restraining order against them that they're now appearing in court trying to just play catch up on not being able to do that. I do believe that that lawyers and the judges and they are able to work in concert with each other and just completely overlook it, whereas the offense now became not whether Brian was using a restraining order to falsely do this, but that Mary was undermining and disrespecting the courts when it was clearly the case did not get the time it was not. I just want to add one more point
thing?
is that she had the woman that used to work for DCYF had mentioned that the judges have access to all of these cases. They have different numbers. They were presented to him, and he just ignored. He did not review the information that was given to him, and he was intentionally misled by a lawyer who was taking advantage of nobody being able to hold her accountable for perjury.
Thank you very much. And do you have anything you wish to give us, paperwork for the record? Because we've got your testimony.
I have documentation of the letter and all the attachments referenced in this letter. I also have all of the transcripts of the court hearings where that this was at 6 months of that. This court hearing went on for maybe almost a year.
We'll accept all of that stuff. Okay, thank you. One question, yes, Representative Katab, and you may put your mic back on now, the one in the witness table.
Thank you, Mr. Chairman, and thank you, Ms. Wydola, for taking my question. I was just wondering if you could just, in 20 seconds, just kind of briefly summarize what was the overall outcome of the case, like what ended up happening.
Put your mic back on.
Are you asking on that court date when we went for the ex parte?
Just overall, what ended up happening with custody with the child, and your sister's now deceased, so I didn't know if there was...
So my sister was deceased, thereby the court just dissolved the case. Brian now has full custody of the child and we are estranged, because that was his intent the entire time, was to estrange my family and my sister from the life of the baby. So he was successful in that, and he just utilized the court to bully her. So there was nothing else we could do after that point. Yeah.
Other questions? Seeing none, thank you so much.
Thank you for your time.
And we'll look forward to getting whatever paperwork you want to give us at some point. What's that?
Where can I submit that?
Oh, you can give it to the researcher over there. Chair recognizes Matthew Ruthier.
Good morning, board members. Thank you. I mean, I have a list of issues in my case that would occupy more than 5 minutes, so I'm just going to give a brief synopsis for you. My intent is to submit this electronically after the fact, after I clean it up, but I'll briefly go through some of the issues. I guess one of the main issues was failure of due process in regards to a parenting plan. My case started in Hooksett and initiated in 2018. Temporary hearing was held in January of 2019. At that time of the temporary hearing and the order which came out, there was no parenting plan at all. It was about a paragraph or so stating, you know, the visitation. It initiated by me in 2018 by filing an ex parte because I was not being allowed to see my daughter. That lack of a parenting plan lasted until 2020. At least 3 motions were filed requesting the judge to put forth or hold an expedited hearing to provide a parenting plan that would allow for vacation, holidays, and the like. That was denied until the final hearings, which in total there were about 6 final hearings before we got to that point. Throughout the matter, there was obviously issues as far as not providing finding of facts, both in property division, in downward deviation of child support, as well as alimony. That case got remanded to the Supreme Court in 2021. It got remanded back to Hooksett, now under a new judge because the original judge was retiring during the first portion of the hearings. She made that very clear to us during the hearings and said her time was limited, so we needed to wrap it up. Unfortunately, on the remand, the Supreme Court remanded that all property division be reheard. That did not happen, and so we are in appeal number 2. Some other issues that I guess are of concern to me, and people have brought up the problem with attorneys making false statements, the issue of perjury. The opposing counsel, during the first session of my hearings, I was represented by an attorney. That attorney has since had to step down under investigation. I filed a complaint against that attorney in 2020, which was denied after being very diligent with the attorney discipline office. I went through files to see how many other complaints were lodged, and there were a total of 8 docketed complaints, which again, docketed complaints are only those which rise to the occasion per the attorney discipline office. When I finally was able to go review files due to COVID in 2021, I had found that that particular attorney had another docketed complaint, which consisted of providing patent services without being a licensed patent attorney. The number of complaints against this particular lawyer were extensive. And again,
How are you along before the clock runs out?
Sure.
What is your point that we should consider as a
The
committee?
point is that the Attorney Discipline Office is run by the Supreme Court, and it is operated by, again, other lawyers. There should be an independent committee to pursue the matters at hand.
Okay, good, thank you.
You're welcome. So one other issue that came up, and I'll try to be brief, is I was ordered to pay child support through the Bureau of Child Support after paying on time for 4 years. After dealing with the child support office, they assumed or made a claim that I had an arrearage, which I did not. I had argued it, and it appears that the Child Support Bureau does not provide documentation to the public of how they calculate arrearage, and thus people are left in the dark, not knowing exactly how to do that. The judge in my matter refused to calculate arrearage and pushed it to child support, and there were no findings to prove why
30 seconds.
I should be paying through the Bureau. So now my paycheck is obviously attached.
So there was a judge, this doesn't count against your minute. So there was a judgment made against you, but there was no proof or reason as to why. It just was said. Is that what you said?
Correct.
Okay.
Thank you.
Got about another 20 seconds.
So in that matter, again, part of the issue is there's a lack of findings, which is consistent, I think, and something that's an overwhelming scheme that people are having to deal with, being forced to continue, to file an appeal. And the process, again, appeal is at least a year. And, this just continues and continues and drags out. I think the main factor is that this committee could form a decision or, I guess, make a suggestion that the format of orders are the same throughout, minus the narrative, which leaves more, individuality to the judges. There is no checklist item for making a decision, and these decisions are all over the map, talking a lot about history of things, but not necessarily hitting the points of law and the facts.
Any questions for the witness? Anybody? No? Seeing none, thank you so much.
Thank you.
You covered a lot of things very succinctly. Do you have anything written you want to give us?
I will submit this electronically if that is fine.
That
I just
is
got some
fine.
Cleanup to do on it. Thank you.
Yepper. Chair recognizes Nicholas Rinaldi. He said time needed to speak, 5 minutes. Yeah. And you've given us this is one document, not a lot of documents with multiple copies? Is that
So
right?
what I've provided with you is that's the status of my case on everything that's been filed.
Okay, good. Thank
Okay.
you. Now we can start the clock.
And the reason why I did give you that is because my entire case was botched.
Okay.
So I'm going to start off that a judge acting without subject matter jurisdiction is acting without just judicial authority. Cohen's versus Virginia, 19 U.S. 6 Wheat, 264 404 5 LED 20 257 1821. The U.S. Supreme Court in, I'm sorry, I'm just going to spell it, SCHEUER versus Rhodes, 416 U.S. 232 94 SCT 1683, 1687, and 1974 stated that when a state officer acts under the state law in a manner violative of the federal constitution, he comes into conflict with the superior authority of the Constitution, and he is in that case stripped of his official or representative character and is subject in his person to the consequences of his individual conduct. The state has no power to impart to him any immunity from responsibility to the supreme authority of the United States. Okay, so that would bring us into a section 1983. That's when it provides an individual the right to sue a state government, employees, or other acting under the color of state law. So my name again is Nicholas Rinaldi.
Mr. Rinaldi, let me go back to the very beginning.
Sure.
This is, you're speaking to a judge acting
My judge
without,
is actually Judge Garner, who testified here. So.
without subject matter jurisdiction.
Correct. They
Oh.
lose their subject jurisdiction when they are in the process of committing felonies and violations of state and federal laws.
I just read about this last night. Please continue.
Okay. So I'll get to the short, because I only have a short amount of time. What we need to be looking for, and the reason why we are here, because we are here, is Racketeering, Influenced, and Corrupt Organization Act. RICO. We have judges, lawyers, government officials, all acting under the color of law. You've heard it here today, folks. They are, let me see here.
I think to help with what we're receiving from you, could you speak specifically to
Yes.
how this is a violation, how in your particular instance, there was somebody presiding without appropriate subject matter jurisdiction? Briefly, I mean.
Yes, so I'll just go over my letter intent to sue.
Okay.
So, federal violations, violation of 18 U.S. Code, deprivation of rights under the color of law, violation of the False Claims Act. People, we have all these laws already in place. We're just not applying them. The judges are aware of it. They know what's going on. They didn't go through 6 years of college to be dummies. Judge Garner was my judge. He's still my judge, and he's actually a very intelligent man, and he's the one that corrected my case. So I am sitting here bearing witness that my case has been corrected, and I have full custody of my children. 0 child support, but I had to go through hell to get there. And it was basically because of one single attorney, Kurt DeWilder. We have... In our court, we have violations of 42 U.S. Code, interference, coercion, intimidation, violation of 18 U.S. Code of assault. Assault is not a batter. Assault is not a batter. My first day in court was with Judge Greenhall. I showed up at 9 o'clock for a 9:30 appointment. The judge didn't show up until 3 o'clock. I left. Oh, I know. I've said that quite a few times. That afternoon, I had an appointment for a $250,000 bid on a project that I had lost because of the judge. And when I left the court, that judge told me he was going to throw me in jail because I brought it to his attention that that was the lowest a person can go. After 15 minutes, I don't care who you are. If you're not going to show up, you call and you cut everybody loose. It's that simple.
Okay, you've got about 30 seconds left, so let's have a couple of real specific things we can get.
So
our
real
teeth into.
specifically, I've been false imprisoned. I've had my 4th Amendment, 5th Amendment, 14th Amendment violated. And I passed a psych eval that I did not ever want to give to the state because my personal information is my personal information, and that shouldn't be shared. And I am under ADA. ADA. I have attention deficit hyperactive disorder with explosive personality syndrome.
Mr. Rinaldi, would you take questions from the committee? Do we have any questions for Mr. Rinaldi? Seeing none, thank you so much. We've got a big document that somebody's going to read this summer. No, I mean this document here. Put your mic back on, please, sir.
That there is a summary of my case.
Are you submitting this to our records?
I'm submitting that to your record and in hopes that you guys would pull the whole case because I've had the ability to start from the beginning and go through to the end and receive my custody, and we're working together as co-parents.
This is wonderful. Thank you, sir. Appreciate this. We're divvying up all the work over the summer, and somebody's going to have some fun with this one. Chair recognizes Donald Gilbert. I'm now working into the batch of, we've seen you before and we missed you. So here you are again. We've got everybody for the first time, and the remaining cards are the second chance here. And you have a different matter. Thank you.
That is correct. So obviously, thank you, Mr. Chairman. Obviously, last week you heard my testimony and rebuttals of some of the prior testimonies. I am still going to follow up with that with both written and oral testimony
Appreciate
to
that. Thank you.
specific laws that were violated and need clarification. I was not prepared to testify that today.
And flag it when you do as to the date so we don't
Correct.
mix them up. Okay?
Correct. Not a
You may
problem.
begin.
Thank you. So today I am here, obviously, to continue this journey. As noted last week, I have over 13 years of experience in the family court. My earlier years, we were there multiple times a week for different matters. More recently, luckily, we've been to only about every 3 months. For different matters. But currently what is going on, and I think part of that is this committee's oversight and some other things that are going on in the state, is over the last 6 months, we have had significant delays of process. There is currently 7 outstanding motions from multiple variations of timeframes over this last year, or 6 months. Starting with January, this is a guardianship matter. The guardian had filed to remove the no contact provision that the court imposed 1 year prior without anybody's request. It was for me to not contact the guardian. We were not able to hear that because the guardian ad litem did not show up at the February hearing. So that was postponed to March. During the March hearing, there was testimony that possibly DCYF was going to be getting involved. The judge ordered that DCYF basically gets involved and announced DCYF is dragging their feet at getting involved, to say the least. The Office of the Child Advocate is actively overseeing these matters. The Ombudsman Office is actively overseeing these matters, and I do thank them for coming and testifying today. So with that, to back up a little bit, in January, February, somewhere around that time, I also filed a motion to conjoin DCYF to the guardianship of this child. Unbeknownst, I really did not want to, but it was a necessity because of what was going on. The court still has not heard any of these motions. We were scheduled for March. We heard that potentially DCYF was stepping in to file a CHINS petition and place this child into residential custody. DCYF has not done so. The guardian ad litem, and myself have asked for DCYF, the court has asked DCYF to step in and take possession of this child, and they have refused. Coming forward, so we have some of these motions that are still outstanding. We're waiting to hear them. They were scheduled for June. Get a letter in the mail yesterday stating that the court has now postponed it yet again to now July.
Any reason given?
No reason. Administrative ruling
Okay.
was the reason that was given. The court had decided to maneuver that. Again, there's been other motions filed. Motion to indeed have a hearing on the no contact provision that's preventing things. There's a motion to have access back to the child's records because juvenile justice is requesting my involvement in that CHINS petition process and they cannot go ahead and do so until the judge orders that I'm allowed access to his records again. And again, the court is just continually delaying that. So that was one of the prefaces that I wanted to touch base on today. Ultimately, again, falls back onto my point of last week that DCYF really is to blame for these issues. The judge has requested DCYF step in. DCYF is refusing to step in for one reason or another. I could give you my reasonings. The Office of the Child Advocate could give you their reasonings. But that would be unfair at this moment in time to do that. I will wrap that up there. I will take questions on that in 1 second, unless you would like me to answer questions. But I do have one other quick point that I did want to make.
Make the quick point.
Sure thing. So to follow up with child support and whatnot, child support has been issued for myself pretty much the entire time, regardless of the child living with me full time or not. And there's 2 children involved here. Currently, one child is under the custody of the state. I am ordered child support to the state, but the state does not hold any representation from the court that they're allowed to get restitution for this. They're the ones that have been delaying these proceedings to, whether reunification or termination. So that's one issue, that child support seemingly is just being granted, as we all know, is a mandatory $50 a month regardless. So thank you.
Representative Katab.
Thank you, Mr. Chairman, and thank you, Mr. Gilbert, for taking my question. So I'm a little bit confused here. If you could just give like a little bit of background. Are these your 2 children that you're speaking of, and you're saying that one of your children, the court has ordered DCYF to take custody of, and they haven't? Are these your own children you're speaking of?
So yeah, so the first matter that was notified last week is one child. We share the same father, same mother for both of these children. The child this week is under the guardianship of his grandmother with significant issues of allegations of neglect and abuse going on. The court notated to DCYF and has reported to DCYF their own concerns and the pleas from all parties to have respite and residential care for this child. And ultimately it lies on DCYF for not providing that at request of myself, the guardian ad litem, and the judge.
Representative Macbeth.
Thank you, Mr. Chair, and thank you for taking my question. I wanted to clarify, you mentioned, I believe, that this delay in process, that you have the Child Advocate Office looking into it, as well as the Ombudsman. And I want to know, what is the Ombudsman office that you're referring to, and just confirm that those 2 offices are reviewing this matter of delay in process. Thank you.
So obviously the Ombudsman is the Ombudsman of DCYF. DHHS Ombudsman. They work closely with the Office of the Child Advocate, and obviously I can attest that they are involved. I met with them last week. I meet again with the Ombudsman this week, but obviously under their statutory requirements, they are not allowed to acknowledge their involvement. But they are actively involved. They have been since the beginning of this year, when significant critical incidents happened in that first instance.
Thank you.
Listening to your testimony, Mr. Gilbert, I just know from the Medical and Counseling Office, of which I'm part-time CEO, if one of our professionals is late, it is the obligation of the front desk personnel to let everyone in the waiting room know, and know why. Not just, oh, she can't be here. Well, obviously. But if she had a flat tire, or there was a medical emergency that she had to attend to at the hospital, or something like that, people sort of feel like they're being treated with some respect. Delays happen.
That would be correct.
And so am I hearing, if the court says we can't hear it until July, One sentence of "we are waiting on so-and-so to do such and such," to me, doesn't betray confidences, secrets, or lack professionalism. It treats you with respect and gives you a reason why. It's just not they've all gone fishing. Could be there's not enough judges. We're working on that. But something. Am I speaking to your point earlier?
So that would be correct. And obviously, as noted, there's a lot going on behind the scenes, as you can imagine.
Sure.
We do have the preface that things are moving for both matters, but the parties at B are not being, there is those secrecies. And we do feel that it's one and the same. We do feel that the court is not being fully forthcoming. We do feel that the division is not being fully forthcoming. And both myself, the Office of the Child Advocate, and the Ombudsman are fairly on the same path of we need to open up these doors. We need to stop the secrecies. We need to be forthcoming. Ultimately, it's for these children. These children need to know what's going on in their lives so that they are not adversely reacting to what is going on in their lives.
Would it be fair to say, running parallel with this, if the judge asked the DCYF to do something, and the DCYF has not done so, would it be legitimate for the judge to ask why? Either we don't think this is anything we should be involved with, which then says to the judge, go find somebody else who will. Or we're overworked, understaffed, underpaid, and underloved, which is true for all of us. Yeah. Rather than just blowing people off.
So that would be correct, Chairman.
I mean, this is really a push question.
That is where my baseline of what my end testimony and changes for this committee ultimately lies with is we are seeing DCYF continually. The judge is ordering specific things, and DCYF is, again, those prior matters are DCYF proposed orders. So DCYF is proposing these orders for the court to order. We're seeing that DCYF is not following the own orders that they propose.
And there could be very legitimate reasons why a reasonable person would say, yeah, you got it right. But let's know them.
Exactly.
Thank you.
Thank you.
If I were, and I'm using the subjunctive voice for an English teacher, a person with all power, I would make this different, and maybe we can make recommendations. So thank you so much.
Thank you.
Yes, sorry, didn't see your hand earlier, Representative. Representative McMahon.
Yeah, I didn't have it up. I was awaiting completion of your intelligentsia. So
I'm going to take that as a compliment. Thank you.
is.
Okay, good.
Mr. Gilbert, last meeting we had, you indicated you've gone through 15 GALs. And what you what you got a decision on allegedly today was relative to the, you filed a motion to conjoin DCYF to the custody of a child. Does that de facto eliminate the GAL participation?
So it would de facto that GAL, it would then most likely under the guidelines of 169C, it would then represent either a CASA worker or another GAL, or we could go ahead and appoint the child their own attorney, which is currently in the process. We have a motion in that first matter to appoint an attorney that's been waiting for determination since March.
Just one follow-up.
Follow-up.
Thank you, Mr. Chairman. Then, and in terms of getting your guidance on what ultimately the committee will consider for real or proposed changes to rules of operation, what would you say, what do you have in your mind in how to facilitate a more expeditious process if we're not getting, like you indicated just a few sentences ago, a DCYF not responding in a timely fashion?
So again, that's something I need to finalize that testimony and written documentation for you, and that will be coming. So I would appreciate that time to be able to answer that for you in a more knowledgeable fashion for you.
And outside of DCYF, what time would you speculate that would take place? The
For
work you just said you were going to do.
so I was preparing that for this week. There was a lot of issues that I don't think I'm going to have it ready for next week. I believe the following week is Memorial Day weekend. Is that correct?
Sure.
Yes, I believe it is.
Why
So
not?
I would have to say that I would like to get back to you that first week of June. The committee has notated that they are preparing to possibly hear in June as well. I would like until
Okay.
that first week of June.
We are planning on meeting the 16th and the 23rd of this month. We've announced we're taking the day after Memorial Day, the day after Memorial Day being the 30th off. We so far has said we're probably going to meet June 6th. 13, it looks like we're trying to arrange a road trip. The 20th we might be meeting. So that hasn't been set yet, but I'm leaning that way and I'm waiting for consensus to build. But we can always take electronic testimony. Representative Katab.
That's exactly what I was going to say, just that you could always submit it to us electronically, you know, instead of coming back out. If you were having scheduling conflicts, you could always email it over to us.
Sure thing. Thank you. No, it's more just I'm a very busy person creating a lot of meetings with a lot of officials here in the state.
We're honored you included us.
So that being said, I do think, again, my timeline was a little off there. So 2 weeks out would be the 23rd. I do believe I could have that ready for this committee for the 23rd.
We have 168 hours in the week and 2 clerks. So they each work 82 hours a week on this committee alone, would you believe? So they'll be happy to take your testimony. Okay, those were
Thank you, committee.
smiles, I think.
It's under appeal.
It's under appeal.
Thank
Okay,
you for your
thank you.
time.
Anything else? Good. Before we call the next witness, I want to thank a couple of you who, maybe you're still here, who basically pulled your pink card because you said you would not be ready to give what we need in the format we're receiving it and in the time framework we're setting, and you'd like instead to testify next week when you can do that. So hip, hip, hooray. Thank you. Now, Mr. Albrecht, are you going to be presenting a specific slice for us to consider according to how we've been doing it? Are you got another one? Because this is your second go round. And the correct answer is yes, sir, I am.
Respectfully, Mr. Chair, in light of most of the prior testimony I've heard, I only wish to add 2 very short comments.
That's why you asked for only 4 minutes.
That was put in earlier before I heard other people say everything I already wanted to say.
So it's 4 or fewer.
Fewer. So I think Mr. Kelly already said it much better than I could, so I won't repeat it. I think Ms. Wydola also said it much better than I could, so I won't repeat it. The only thing I will repeat is prosecute perjury, because they both said it, and I think you need to hear it a third time. To that, I will also add, only in light of Mr. Rinaldi's testimony, I think there are a lot of people here who have docket summaries approaching the thickness of his, I don't know how many pages it is, who would,
That many,
yeah, we've got a lot of those.
I know you do.
And we've got a lot of allegations in those that multiple judicial officers have botched it. Again, allegations. And I think a lot of us would like to know, and this is a rhetorical question, in light of that, how do we get a Judge Garner to step in and sort of fix it the way Mr. Rinaldi, you heard from Mr. Rinaldi.
That is a topic for us to discuss.
Exactly.
In the previous iteration of this committee, when it was redresses of grievances, it was pretty darn case-specific, people-specific, with some pretty tough recommendations that had teeth in them. We're doing it differently, as you know, but that does not take away the need. And so that is something we need to look at as a committee, in my opinion. How do people who have a real beef with somebody in the system get justice. We've heard of a judicial review committee. We've heard of suggestions for at least one other body. That's fair game for this committee in general.
Exactly. Thank you very much. I would strongly exhort you to do that. And as one final request for anyone watching on YouTube, could you please state for the record the best way for them to submit electronic testimony? Email,
Would you
gory
be my
details.
publicity agent? This is really good.
Yeah.
Thank you. How do they do that, clerks?
So you can go right online, and if you go to the New Hampshire General Court website and you pull up, I'm going to do this right while I'm talking to you to make sure that I tell you the correct thing. If you go under committees and you go under the House and then under standing committees, you'll find our special family, pull it up, special committee on the family court, the family division of the circuit court. You will see a button that says email all committee members. And if you go ahead and select that, it will open you up to emailing up all of us. And that will be the House Special Committee on Family Div Circuit Court at ledge.state.nh.us.
And for those of you keeping score at home, say that again.
I will say it one more time. Hold on one second.
This is how you get in
101.
touch with us. He is filling time until she tells you. Exactly.
It will be
You
House
have a card, Betty?
Special Committee
No.
on Family Div Circuit Court at ledge.state.nh.us.
Thank you very much. Nothing further from me unless you want to give me a hard time.
Representative Smith.
It's tradition.
Well, thank you. I'm pleased to say that I'm not part of that tradition. I'm not interested in giving anyone a hard time. I'm interested in defining a problem and identifying solutions. As to your comments about perjury, that is certainly nothing that this committee will enter into if in fact perjury has been committed. That is not for us to decide, and you know that. What I do want to know from you, because you've spent a lot of time thinking about this, is what are your positive recommendations to this committee about how improvements can be made in the family court? One that I believe you have talked about is transparency through the process. One that you've alluded to is accountability, knowing who is to be held accountable for what has to happen. One that's been alluded to is the need for consistent training and oversight of that training. I mean, these are things that we legitimately can recommend, but you've given it a lot of thought. What else do you see that we could recommend either to the court or that the legislature take action on?
I think first and foremost, I would be grateful if every member of this committee viewed the loss of a parent, the ability of someone to parent their child, as a sanction worse than imprisonment. And in many individual cases, perhaps that sanction is warranted. But indeed, it is a sanction, in my opinion, worse than imprisonment. And in criminal cases, by way of contrast to family law cases, if there are allegations of wrongdoing, and I would refer you to Article 14 and 15 of the state constitution, criminal defendants get to hear in no uncertain terms, very explicitly, what it is that they're alleged to have done wrong. Whereas in family law, I think you heard a lot of testimony earlier today where people feel that decisions were made arbitrarily, where even upon the filing of a motion for clarification, they don't understand what it is that they're even alleged to have done. We may be going a little, I could even point you to a specific statute, or say 173B, Roman numeral 6, that says the court shall state, I can't read my own writing, but to paraphrase, the request of an agreed party in writing the reasons for its decision. I would allege with frequency that's not happening, even when it's spelled out in a motion for clarification. And so I think we need to raise the standard and have a presumption of 50-50 equal shared parenting, again, a presumption, whereby if that's not happening, one of the litigants should come up with some very good reasons why, and then the judge has discretion. But I'm hearing that judges have far too much discretion. Children are being sent out of state. All of these allegations are coming up based on the emotional demeanor of someone in court, and you lose your children for that. Raise the standard. If you're going to lose your children, make it crystal clear what somebody did wrong and why they are subject to such severe sanction.
Thank you so much.
That's very helpful.
If I could follow up. I think all of us on the committee understand that it is likely that in close to half of the cases that the family court hears in these matters, or in close to all of the cases that the family court hears in this matter, half of the people are unhappy. We live in a society where we think of things as wins and losses, and we don't quite understand the gray areas in between. The cases that have come before us are not cases that are coming in an appeal. They're certainly not cases which are being presented to us with both sides explaining their position, nor should they be, because we are not a trial. We are not an appeal court. We are a legislative body. So what I'm trying to get from you is what we can do in the legislature to make sure that the court best meets the need of all of our citizens. And you've given us some examples. It's not a question of us recognizing the seriousness of this matter. I think every one of us on this committee understood that before we agreed to be on this committee. That's not something that we need to be convinced of. But where do we go from here is what we're trying to figure out. We are not going to review your cases. We're not going to change the outcome. What we are looking at is the system itself. Are there things that we can do? We certainly know we need more judges. We certainly know that we need additional revenue to pay for those judges. We've had examples today of other expenditures that might very well improve the situation, including the opportunity to have social workers involved in cases in a way that differentiates themselves from GALs or guardians or CASA or any of the others. all of that we've heard. Now what we need, we've certainly heard that training is not consistent and that oversight is not consistent. That is something that this legislature can clearly require of the judicial branch without violating the separation. But it doesn't bring us forward to hear the very serious concerns that you all have, because we understand that you have real concerns. We need to know now what. And the now what isn't going to include a reversal of your court cases, not through us. That would have to happen someplace else. You are organizing so successfully people who believe they have not been treated fairly by the court. And I see your emails. I know the people you've brought here, and you've been diligent about that. But if we just rehash the concerns, that might be good to have given you, an opportunity to rehash them, but it doesn't bring us forward. And what I really hope from you is a reflection on what, given all the concerns, how can we make the system better?
I think a full answer to that question from me might be best done in writing, not ad-libbed in front of this committee.
That would be terrific. Thank you very much for that. And thank you for your concerns.
But as one brief preview, I would echo your sentiment. If we could get rid of the winners and losers and have more winners and winners, absent clear and convincing evidence of abuse, that would be a wonderful thing.
I was to thank the vice chair for a wonderful, wonderful wrap-up at the end of a long and busy day. When you submit paper or electronics to the committee, it does not automatically go into the committee file. I have to vet it, or I may ask my vice chair to vet it. And if it is something that we believe should be in the permanent file, then it will be given the clearance to the clerk to place it accordingly. That statement that I make at the beginning of every week's committee meeting says that. We do not have to put it in the file. It ultimately becomes my discretion to do so. So you can send that to me, you can send that to all of us. I'll look it over. If it is as promised, it'll go into that file.
Thank you very much.
30 seconds, Representative Long.
Thank you. Thank you, Mr. Chairman. Yeah, with respect to winners and losers, I was never a winner or a loser. My child was. And I look for what the child wins or loses, not what a parent wins or loses.
Representative McBath.
Thank you. I just wanted to follow up. I believe that you cited the statute RSA 173B, Roman numeral 6, when you were talking about transparency of judges and what they needed to provide in their orders.
Yes.
That 173B is actually a domestic violence statute.
That is correct.
So that's not what family court judges are determining parental rental responsibilities on. Was there a different statute that you wanted to cite in regard to that, or?
Respectfully, I believe judges are making parental decisions all of the time in the context of DV cases, and it's a huge problem. And respectfully, that actually was the statute I was referring to, because they don't explain why orders are issued or extended adequately. And it cycles right back to, by way of contrast, in a criminal case, people get to hear exactly what they're alleged to have done wrong and why.
Okay, thank you.
Thank you.
And with that, I close the special committee's meeting for May 9th.